You know, a neighborhood spat over a few junk cars sounds pretty simple, doesn't it? But what happens when that complaint just snowballs and ends up in a formal hearing, a full-on legal showdown? Well, that is exactly the story we're going to break down right now.
So here's how we're going to tackle this. First, we'll look at the complaint that started it all. Then, we'll get into the HOA's unexpected delay and why that happened. After that, we'll dive into the testimony from the hearing, unpack the judge's final decision, and finally, figure out what we can all take away from this whole thing.
All right, let's get right into it. This whole story really kicks off with one person, a resident named Mr. Samuel Schechter, and his frustration reaching a boiling point. And the heart of the matter is right here in this quote from his petition. On January 16, 2015, he filed this, saying his property owners association had, quote, failed to take enforcement action. I mean, to him it was simple. They were junk cars, dots against the rules, and the people in charge weren't doing anything about it.
And you can really feel the frustration building when you look at the timeline. He sends in his complaint on September 8th. Then, nothing in October. Still nothing in November. Nothing in December. So after 4 whole months of what felt like being completely ignored, he finally decided, okay, that's it, and filed the official petition.
But every story has two sides, right? So let's flip over to the HOA's perspective. Because their delay wasn't just a case of them ignoring him. Something happened, something tragic and completely unforeseen that changed everything.
At first, everything seemed to be business as usual. Back in September 2014, the HOA board gets Mr. Schechter's list of violations. Standard procedure. They passed that list on to the right guy for the job, Ron Murray. He was the chairman of the Environmental Control Committee, so investigating these kinds of complaints was literally his role.
And this is where the story just takes a heartbreaking turn. Sometime between that September meeting and the next one in October, Mr. Murray passed away. It was sudden and it was completely unexpected.
So, the HOA argued that this was a huge blow, not just personally for them, but for the whole investigation. They had no idea what progress Mr. Murray had made, if any. Had he visited the properties? Had he taken notes? They didn't know. So they had no choice but to start the entire thing over right from scratch.
Now, when they start this new investigation, the board president looks at the original list from Mr. Schechter and finds some issues. There were wrong addresses, some of the information was outdated, so the HOA makes what they think is a totally reasonable request. They ask him, hey, could you please resubmit this on the proper form with updated info?
But Mr. Schechter and his colleague, Mr. Dodge, saw this completely differently. They refused. In fact, Mr. Dodge later said in testimony that he thought the request was a fool's errand. From their point of view, they'd already done the work. Being asked to do it all over again just felt like the HOA was giving them the runaround.
So now you've got two sides completely dug in, not willing to budge. The dispute officially moves out of the neighborhood and into a formal administrative hearing, where they're each going to lay out their case.
And the hearing really boiled down to two totally different versions of reality. You had Mr. Schechter saying the board completely failed in its duty, and his proof was the 4-month delay and photos of the cars. Then you had the HOA saying, no, we acted reasonably, citing the tragic death of the chairman, the bad info on the list, and Mr. Schechter's refusal to help them out.
And a really big point of contention during the hearing was something you'd think would be simple. What was the actual process for filing a complaint in this community? The HOA president, Theodore Pommel, was super clear on this. He testified that the rules require complaints to be submitted in writing on a specific form that they provide. End of story.
But then, another resident, Arrestinine Johnson Stokes, gets up to testify and says something that completely contradicts him. She says she'd filed complaints before and was never required to put them in writing. She just told them and they took care of it. So this really muddled the waters about what the procedure actually was.
So, you've got conflicting testimony, two very different stories. How on earth does a judge make a call? Well, it all came down to a really critical legal idea called the burden of proof.
The burden of proof is basically who has to do the proving. And in this case, that responsibility fell squarely on Mr. Schechter. You see, it wasn't the HOA's job to prove they were innocent. It was Mr. Schechter's job to prove they were guilty of neglecting their duties.
And the bar for that proof isn't what you see in criminal trials, beyond a reasonable doubt. It's much lower. It's called a preponderance of the evidence. All that means is you have to convince the judge that your claim is more likely true than not. Just tip the scales past 50%.
So after listening to everyone, the judge reached a really important conclusion. He decided that the board's actions, restarting the investigation, dealing with a flawed list, and asking for a new one, all after the tragic death of their committee chair, were, quote, reasonable and prudent under the circumstances.
And because of that, the petition was dismissed. At the end of the day, the judge ruled that Mr. Schechter just hadn't met his burden of proof. The evidence he brought forward simply wasn't enough to show it was more likely than not that the HOA had dropped the ball. So, where does that leave us? Let's get to our final section and talk about what this very specific, messy neighborhood dispute can actually teach all of us.
And just to wrap it up, the judge's decision became the final, official word on the matter. Nobody appealed, nobody took any further action, and the case was officially closed.
This whole case leaves us with a really fascinating question to think about. In any kind of argument, where does your responsibility stop and the other person's begin? It's a great reminder that even when you are 100% sure you're in the right, the outcome can come down to cooperation, following procedure, and ultimately, who is legally required to prove the case.